Hello everyone, welcome back to the channel. This is part 2 of the National Green Tribunal Act 2010. In today's video, we'll focus only on the chapter 2, that is the establishment of the tribunal. So section 3 says that it is the central government which by notification will establish a tribunal known to be the National Green Tribunal, and it shall exercise the jurisdiction, powers and authority conferred on such tribunal under this act. Then coming to the composition of tribunal, it shall consist of a full-time chairperson and 10 to 20 full-time judicial members. They are appointed by the central government, and then 10 to 20 full-time expert members, they are also appointed by the central government. Then it is given that the chairperson may also invite any one or more person having specialized knowledge and experience in a particular case before the tribunal, just to assist the tribunal. They are not member, but they are coming only to assist the tribunal, since they have the particular specialized knowledge with regard to that particular case. Okay, then it is said that the central government may also specify the ordinary place or place of sittings, the tribunal and the territorial jurisdiction falling under each such place of sitting. So this is not the tribunal's power, it is the central government power to specify the place of sitting for the tribunal. So far as the principal benches are New Delhi, and there are many regional branches like Pune, which is Western Zone bench, and Bhopal Central Zone bench, and Chennai is for Southern Zone, and Kolkata is for Eastern Zone. So for these each regional zones, which is the jurisdiction, will also be decided by the central government. Then again, the central government, in consultation with the chairperson, make rules with regard to the person who shall be entitled to appear before the tribunal, the procedure for hearing applications and appeals and other matters, and the minimum number of members who shall hear the applications and appeals in respect of the cases. Okay, so it is also given that the expert members and the judicial members should be equal while hearing such application and appeal. Okay, then also the central government may provide the rules relating to the transfer of cases by chairperson from one place of sitting to the other place of sitting. This is what about the establishment and composition. Now let us move to the section 5 of the Act, that is the qualifications for appointment of chairperson, judicial member and expert member. So for chairperson as well as judicial member, that person must be an judge of the Supreme Court of India or Chief Justice of High Court. For a judicial member, the person can also be a judge of the High Court. Okay, for chairperson 2 criteria are given, for judicial member 3 criteria are given. Then for the expert member, he should have a degree in Masters of Science with the doctorate degree or Master of Engineering or Master of Technology. Okay, so in this degree, you should have experience of 15 years, and in that 15 years 5 years should be a practical experience in the field of environment and forest. This is you should have in the mind, and to that the practical experience should be in a reputed national level institution. And in the other criteria is, so you should take note of this R. So either A or B is the qualification. So the B qualification is that you should have administrative experience for 15 years, and in that 15 years 5 years should be related to the environmental matters in the central or state government or in a reputed national or state level institution. So here only national level institution is given, but in second criteria both national or state level institution is provided. Also, as an additional restriction, they have mentioned that you should not hold any other office of profit during this tenure period. And in the fourth point, they have said that like some post employment criteria restriction, that is for a period of 2 years after holding the office. You should not employ in any other jobs, okay, jobs or employment. That is what given in section 4. So there is a cooling period after which he can join any employment. So that is 2 years after completion of his tenure period, he can go for any other job, okay. Then moving on to the next, section 6. Section 6 is about the appointment of chairperson, judicial member and expert member. So these members are obviously appointed by the central government only. But in case of chairperson, the central government will consult the Chief Justice of India. Okay, this you have to remember. But in case of judicial member and expert member, there will be a separate selection committee. Okay, based on the recommendation of such selection committee, the central government will appoint such members. Then coming to the tenure, it's very easy. 5-year period is the tenure for the chairperson, judicial member and as well as expert member. But in case a person, judge of the Supreme Court, is appointed as a chairperson or judicial member, remember, judge of Supreme Court, then he can hold the office only until the age of 70 years. That is, that if the person is a chief justice of high court, then he can hold the office only till 67 years, and the same is for a judge of a high court, only till the age of 67 years. But in the case of expert member, it is bit early, that is 65 years, okay. Then section 8 is about resignation. Since these person, chairperson and the members are appointed by the central government, they should resign by writing a notice under their hand addressed to the same central government, okay. Then coming to 9, the salaries and the conditions of service, these will be as may be prescribed. There is not necessary to concentrate on these section part, because the question for the UGC net will be like giving the headings, that is the short title, they will ask you to arrange as per the chronological order. So you should remember that the resignation will come first, then the salaries, then the removal, okay. Like this you should have the memory of just the short title in an order, nothing much for the UGC net, okay. Then section 10 is about the removal and suspension of the chairperson, judicial member and expert member. It is said that the removal will be made by the central government in consultation with the chief justice in case of the chairperson and judicial member. So it is not for the expert member, only for the chairperson and judicial member the central government will consult with the chief justice of India. So on what grounds they may be removed is if he has been adjudged as insolvent or convicted for an offense and it involves moral turpitude and has been physically and mentally incapable and has acquired such financial interest to affect prejudicially his function. It is already said that he should not have any office of profit, but if he does so, he can be removed. Also has so abused his position, okay. Then it is said that when they are going to be removed, there should be an inquiry made by a judge of Supreme Court, okay, and these chairperson or judicial member should be informed of the charges against him for the inquiry, okay, and they should be given opportunity of hearing also. This is what given. And then in the third subsection it is said that central government may suspend that particular person during the inquiry period, and also the rules and regulations may be regulated by the central government with regard to this inquiry, okay. Then 5 says that the expert member, how he can be removed is on the same grounds provided for the judicial member only, but there is not there is no necessary for consultation of the chief justice, that you have to remember. Also the same, the expert member should also be given an opportunity of hearing. Then coming to section 10A, it is not necessary, you can skip that part. And then section 11 is about the vacancy. It says that in case the office of the chairperson of the tribunal is vacant by reason of death, resignation or any other reason, such the judicial member of the tribunal may be authorized to act as a chairperson during that period until the next new chairperson is appointed. That is what given in section 11. And section 12 it says that apart from chairperson, expert member, judicial member, the other officers, the other employees which is required to assist the tribunal in discharge of this function may be appointed by the central government itself, and the recruitment of such officers shall be made by the chairperson, and they will work under the superintendence of the chairperson. The salaries and allowances will be determined or prescribed by the central government itself. Then coming to the section 13, it provides another power of the chairperson, that he has some financial and administrative powers. So this chairperson can himself act. Also, he can delegate such powers to the judicial member or else to the expert member or the officers of the tribunal, but they should act under his direction, control and supervision of the chairperson. So this is what provided under chapter 2. To continue learning about the other chapters of the NGT Act, please view to the part 3 of the video. Thank you for watching. Please subscribe to the channel and give a like. Thank you.